Mamdou Coulibaly versus Theodore Farnsworth.
Good morning, Your Honor. It's Kimberly Stein and Gus Plangus on behalf of today defendant Mr. Roderick Vanderbilt. We do also represent other defendants, but we're not here in that capacity today.
Good morning, Your Honor. Mamdou Coulibaly in behalf of Plaintiff.
The one thing, Your Honor, I would ask is to remind the court on June 5th, you had ordered as through entered that online access is limited on this case. And I do see we have a lot of, but I know you have the other calendar. I don't know how we want to handle that.
So I assume everybody on there's probably for 9:30 or 9.
Pretty close, we got one more case after that.
Yeah, so.
Okay, I just want to make sure.
I have like, I don't know, a total of like 50 cases this week, so.
Okay.
We'll try our best.
Thank you.
So I've reviewed plaintiff's motion for TRO and preliminary injunction against Vinco Ventures. Defendant Vanderbilt's opposition to that and counter motion for sanctions. Plaintiff's reply. And then Vanderbilt's reply in support of the counter motion. Declined to deny the motion for TRO and preliminary injunction for all the reasons set forth in opposition. Motion believe fails, to even come close to the standards for TRO and or preliminary injunction. Counter motion inclined to deny without prejudice, with a door wide open to re-raising that on any other similar motion that gets filed here in the future. So that's what I'm inclined to do, and again, I'm going to have to limit your arguments. This one's not nearly as complex as that last one, so 5 minutes total. Mr. Coulibaly, go ahead.
Yeah, Your Honor. Before I start, I just want to apologize for the last time. But this motion, Your Honor, we have provided the argument that have been entered, and we understand that the court is inclined to deny our TRO. But the fact is, the company is about to forgive more than $64 million of money that's owed to the company, and that's why we have bring this motion. And the only thing we're asking here is to maintain the status quo, because in this litigation we have a claim of corporate waste, and it is clear, as we have provided the evidence, that there will be a clear waste of corporation money, because forgiving $6.4 million of money that's owed to the company is clearly wasteful, and there is no argument to support that. But we will respect the court inclination, and I will let the opposing counsel speak.
Thank you.
Thank you, Your Honor. Again, I think per your inclination, just a few points. Unfortunately, we have a plaintiff that is not only trying to run a company, he's trying to run a company that's a nominal defendant, that it's already been defaulted in this case, which is another issue, which will be another subject of another motion another day. But with regards to your counter motion, I understand you're saying without prejudice, but this is the fourth motion on the same issue. And I would ask the court to reconsider with regards to the counter motion at this time, because continuously, this has to stop. This plaintiff has tried to run this company ignore the business judgment rule. This started May 25th, 2023 on the first motion, which was denied, and on June 12th. Then we have September 20th, filed another emergency motion. That was then denied in October. Then files the third motion for preliminary injunction and limited its discovery, wanted a special master. That order was entered November 6th, and now we're here again.
So part of what I run into sometimes, like in this instance, feel free to address this, but like, you know, I get your opposition counter motion. Your counter motion refers, I call it generically, I suppose, you know, the numerous filings being frivolous. That's, you know, what, 3 paragraphs long. A lot of the details you're telling me now are not in your counter motion. And so I'm kind of, you know, if you want me to actually review that type of stuff, why wasn't it in your counter motion?
Respectfully, Your Honor, it's in the introduction of the opposition and counter motion, which was combined. So that is listed. It's on pages, starting on page 4 specifically, goes through, and 5 of the introduction.
Okay.
It is there. And we specifically talk about all of the other motions, and respectfully, I understand you were not the judge prior to inheriting this case. But distinctly, this motion is, and I actually start off in my introduction that this is the latest motion, and it's brought
Yeah, I
before
do
the
recall
time.
reading.
And my problem here is it doesn't stop. It's continuously to cost our client. And as you said, this motion doesn't even come close to the standard for the extraordinary remedy being sought. Again, it's actually seeking against a nominal defendant who's not even a party at this time because they've been defaulted in this case. And doesn't show a reputable harm, can't prove the hardship, doesn't even discuss the need for a bond, then argues we don't have standing except my client, Mr. Vanderbilt, the chairman of the company. The company is still an operating entity. And he was and is still currently the chairman. But he's trying to prohibit and restrain a company and run a company. And again, he continues. This is the 4th time. So I would ask, and again, continue with the inclination that you deny this motion for the TRO preliminary injunction for the basis stated, but also I would ask that the court reconsider granting the counter motion at this point because, again, this plaintiff is doing this pro se, so it's not costing him anything, and he's continued, as this court is aware, to threaten every time that he's going to run up this bill until the D&O insurance runs out. And so I think this is just another motion, and this is the 4th time.
Thank you. Mr. Coulibaly, you have got you've got a couple minutes left.
Okay, Your Honor. The first thing I want to point out, Your Honor, this motion, plaintiff is seeking an equitable relief against Vinco Venture, not Roderick Vanderbilt. So, and the second thing, I have provided the agreement, and the agreement is clear. We just have to look at the agreement. In the agreement, the company is about to forgive $6.4 million of money that is owed to by him by Eightco Holdings, knowing that Eightco Holdings is a company that make money last year. They make more than $75 million. So the only thing we're asking here is that for the company not to forgive. We are not against the company entering into agreement. If you look at our file, our motion, Exhibit 3, we have put the agreement there. And the agreement is clear. That's the only thing we're asking is for the court to prevent Vinco Venture from forgiving money that's owed to them. That's the only thing we're asking, nothing else. And I understand that opposite counsel is saying that I'm trying to harass the client. Actually, that's not true. My point is to be able to save this company, which is in brink of bankruptcy. And it's clear that for a company that have almost no money, how can we allow that company to just forgive $6.4 million of money that's owed to them? And we are just here asking the court to maintain the status quo. And about the sanction, once again, this filing was filed against Vinco Venture. And I understand that counsel have previously multiple times filed sanction against me, pretending that all the other motion was frivolous, but all the time the judge have found that those motion was not frivolous.
Thank you very
Thank you, Your
much. So I'm gonna stick with my initial inclination, deny the motion and for TRO preliminary injunction, because plaintiff has failed to meet its burden of showing irreparable harm, has failed to show, meet its burden there for all the reasons set forth in the opposition. I'm also, though, going to deny the counter motion. This motion may be somewhat repetitive, certainly, but this motion in particular, based on an alleged agreement that occurred June 20th, 2024, that's certainly a change in circumstances from some of those prior ones at least. So again, without prejudice on the sanctions, counter motion, but the motion is also denied itself for the reasons set forth in detail in the opposition. So Ms. Stein, go ahead and prepare a detailed order, put the reasons in there, submit to Mr. Coulibaly for review. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.